Hi there, I'm Patrick Hughes, and I'm one of the founders of Patriots Law Group alongside of my co-founder, Michael Lyons, who happens to be the chair of the Veterans Affairs and Military Law section of the Maryland Bar Association. And this is a follow-on from a presentation I gave on October 16th before members of the VAML, just so that we could make sure that others who might not have been able to attend get the information that focusing in on the collateral consequences, what every criminal defense attorney needs to know about security clearances. By way of background, I'm a former active duty Air Force JAG, and since then I've switched over to the reserve component. I'm now part of the Air National Guard and am a lieutenant colonel with the Air National Guard. Through that experience being in the military and ever since we formed Patriots Law Group, we've been representing people in security clearance matters, and so there are a number of things that may not be recognized by those who don't know that side of the impacts to their clients when they're representing people in criminal matters. And so we wanted to make sure that we helped along and even potentially informed you on triggers and other things, and so potentially even you seeking out a partner who's experienced in clearance matters would be wise to do for your clients as you are representing them. So particularly important to this issue is whenever you are representing a client who happens to be military or a DoD contractor or anyone really holding a security clearance, if they're involved in a protective order, criminal charges, or happen to even maybe have disciplinary issues going on base where they're working, that will probably be impacting their viability of holding a security clearance alongside of the criminal matter that they may need to be dealing with. We're in the DC area. There are so many places, agencies, FBI, NSA, we have Fort Meade, you have Joint Base Andrews, so many other military bases, and so many hundreds of thousands, if not in the millions of people in the area who are holding security clearances of some sort. And so just talking through the ways that people can have issues with respect to their security clearance is the goal of what this presentation is about. So first off, just to work on the terminology, there are a number of different clearances that people can hold. There's also something called a public trust. So I won't really be focusing too much on the public trust, which is basically a determination governed by the Office of Personnel Management. It's under 5 CFR, Code of Federal Regulations, Part 731, and overseen by the Office of Personnel Management, OPM. And that's a determination based on suitability and fitness. The criteria used to make that determination is largely similar to the criteria used for someone to hold a security clearance. In the security clearance matters, we have a number of different levels. You have secret, top secret, and you even have sensitive compartmented information, SCI. So a lot of people will have a top secret TS, SCI security clearance. And so with those varying levels, there can be heightened scrutiny with respect to the criteria used to evaluate and adjudicate whether someone should hold a security clearance. Those who are issued a security clearance, that's with respect to and governed by Executive Order 12968, 12,968, and a document called the Security Executive Agent Directive, SEAD 4. That SEAD 4 document is essentially the Bible for any adjudicator as they're evaluating whether someone should hold a security clearance. It has guidelines A through M, 13 different guidelines setting forth the criteria for analyzing whether someone has the good judgment, reliability, and trustworthiness to hold a security clearance. So the first thing that you need to do to start the process of obtaining a security clearance is first you have to have a sponsor. That could be the military department that you're working for. That could be the employer. DoD contractor, a number of well-known DoD contractors like Northrop Grumman or Leidos or Lockheed Martin. Those are all going to be the sponsors for anyone who's working for them. They'll be the sponsor notifying the agency that they will be working for that they'd like to sponsor the person for the security clearance. And the first thing, again, there are varying forms, different from the public trust, there's a separate form, but for a security clearance, you have to fill out and complete a standard form SF-86. And that's commonly filled out through electronic forms called the EQIP, but that is a very lengthy document asking almost around 30 different sections of information that people have to fill out, providing the information that will then be bumped up against the Security Executive Agent Directive 4, those adjudicative guidelines. And for the large majority of DoD security clearance holders, the Defense Counterintelligence Security Agency, DCSA, will be the adjudicating body. And if it's an agency in the intelligence community like NSA or NGA, those are having their own adjudicative bodies to evaluate whether someone should or should not hold a security clearance. But either way, they're all referring to that SEAD 4 document to determine and use the criteria whether someone should be holding a security clearance. And through that adjudication process, as everyone's hoping, it's granted and there's no issues. But if there are issues leading to either a denial on the front end or along the way, a security clearance might be suspended or revoked because of some issue that pops up, there's due process provided by the adjudicating body or through an appellate process through the adjudicating body as they exist. So one of the things that's happened also fairly recently in time is they've switched to a continuous vetting process with respect to whether someone should hold the security clearance. It used to be that a secret clearance would be good until for 10 years. And then a top secret clearance was good for 5 years without the need to be reevaluated. That's now changed through the automated processes, AI, everyone's using AI now, the automated processes of the adjudicating bodies, they will be analyzing databases, like criminal databases, the NCIC or state criminal databases to know if a protective order has been issued on someone, things like that. And that can raise a flag. And so if a flag is raised and someone has to go through the process of disclosing what has happened, then there's certain things that need to be done with that in the process. And the first one is something, if it's a formal action that's being taken because of something that pops up in someone's record, the first step of the due process is the issuance of a statement of reasons. That's the first formal step. And it will essentially allege in this SEAD 4 document what specific adjudicative guideline has been implicated, or guidelines. As I've seen in many cases, multiple guidelines can be raised at the same time. Some examples of what those guidelines are, people can have financial issues and a credit report could disclose that they've filed for bankruptcy or they're in collections, criminal conduct guideline, H for drug involvement. All of these different guidelines can be implicated based on a crime. So if someone is involved in a drug crime, you may end up seeing that multiple guidelines are raised, like the drug abuse guideline and the criminal conduct guideline. So whatever is at issue you will be put on notice in this statement of reasons, or SOR. That's the formal opportunity to provide a response to help to mitigate the issue or to alleviate the concern entirely by rebutting that it is even a valid issue at all. There's just because a statement of reasons is issued doesn't mean that you can't entirely refute things, much like a criminal allegation, if it's a false allegation or things along that line. This is the opportunity to provide a response to try to convince in the early stages of the process why it should not go any farther, and why the clearance should be reinstated or provided on the front end. If it doesn't successfully, through that written response, sway the adjudicating body, then you have the opportunity to, in some instances, in those who are evaluated by the DCSA, because they're a general DoD security clearance holder, they're afforded the opportunity to a hearing in front of an administrative judge who works for the Defense Office of Hearings and Appeals, DOHA. And in that opportunity, they have the ability to call witnesses, present additional evidence, and attempt to answer the question as to why whatever the statement of reasons and the security concern that was raised has been alleviated or mitigated, such that analyzing through something called a whole person concept, their good judgment, reliability, and trustworthiness is no longer in question, and they should continue, or on the front end, be issued a security clearance. So after that decision is reached, though, if it gets to the hearing stage and a judge is not persuaded that you should hold a security clearance, you have one last opportunity to appeal. In the DOHA process, that means a panel of 3 attorneys working for DOHA. And in that situation, much like any sort of appeal, you have to allege that there was an error at the hearing itself. It's not a de novo review by the DOHA appellate board. You have to find some error that the administrative judge committed, or a lack of proper evaluation of the whole person concept, to try to sway the appellate board that the clearance should not be denied or revoked. In very, very limited cases, almost no situation, but except for a very small and minor limitation, are you allowed to appeal to a judicial court. There's a case in the Supreme Court, it was Egan versus the Navy, which essentially said the courts and judicial action are not permitted with respect to the executive's decision as it pertains to who and who cannot hold a security clearance. So as I said, there's a number of different guidelines that could be implicated, and just thinking as a criminal attorney, how many different ones of these could be implicated. Personal conduct relates to, which is guideline E, it relates to truthfulness, and there's a number of others related to foreign influence and foreign contacts. That's probably not as applicable to a criminal attorney, but you can see how one or more of these adjudicative guidelines are going to be implicated. There is a duty to report others, and that's guided by a different document, the Security Executive Agent Directive 3, which identifies when someone has to report others and when they have to report themselves. And that's an important document. And this is really where I think a clearance attorney could come in and be helpful alongside of the criminal attorney in the representation to make sure that both of these angles are managed properly. Whenever there is alcohol abuse or illegal use of drugs or criminal conduct that is known by a security clearance holder because of something a colleague who also holds a security clearance was observed to be doing, there's actually a duty to report on those specific things. And then the question also, where I'm advising a lot, is when does the person, him or herself, have a duty to report, which this document guides. And anytime someone is arrested, for example, that is a situation where they must come forward and reach their facility security officer, if they're a contractor, or their security manager within the military, and inform them of the event that gave rise to their arrest. Now, there are certain things that are implicated with respect to your Fifth Amendment right, but it doesn't take away from the fact that you still have a duty to report certain events. And so you really have to toe a line as to how much you choose to disclose beside just the fact that you got arrested, or other reasons for why you might need to disclose something is if you are involved in alcohol and drug treatment, or you have some financial anomalies in your situation. Those may trigger the need to self-report. And so guiding a client through what should be said and how it should be said is an important thing in a situation like that. And it's my view that based on the continuous vetting process, in particular, the disclosure is the route to go. I encourage the clients that come to me and to speak with me that probably disclosing is the route to go, because they're going to find it out anyway. And if you are found to have not informed the security office that something that you had a duty to report occurred, then that's going to make it worse. And so, getting ahead of the issue, I think, is an important thing to consider. And now it's just a matter of what information is provided, how it's provided, and the main thing too is then that creates a predicament with the criminal matter, because what will always run faster, in my experience, is the security clearance issues. Whether or not someone's security clearance should be suspended because of them having been arrested is going to happen much quicker than the court's process of a criminal matter. You won't even get to a preliminary hearing before the employer and the adjudicating bodies are likely going to be taking action. So what, again, do you provide as evidence, or what do you say to get ahead of the issue, has to really align with what your plan will be when handling that criminal matter, because then if they don't, then you've created inconsistencies, which is not good at all, and nothing stops that information that you provided to the government from being acquired by the government, right? And so if there's any sort of exchange between the security clearance matter and the criminal matter, you want to make sure that you've adequately addressed that security clearance piece while also not putting in jeopardy the criminal piece. In the end, what's more important, staying out of jail or holding a security clearance? I think then if that's such an obstacle is approached, that we might need to err on not providing more information in the security clearance piece on the front end. But that is why you can link up with a clearance attorney to address all the issues and make sure that the client can make an informed decision on the approach to take. Now, when it comes to the impacts of a clearance, I think it's largely underestimated by the general criminal attorney populace. Just a plea, which might be a great outcome, or a probation before judgment, any of those things might be a great outcome in the case as it relates to the criminal piece, but that could end up being the end of someone's security clearance. And so even if that ends up being the easy and best route in the criminal matter, I think a client's going to want to know the impacts of that to security clearance. And partnering up with a clearance attorney is a great way to just allow the client to be fully informed and weigh the route he or she wants to go on both of those sides. And early coordination with a clearance attorney is really, I think, a useful thing whenever that issue is spotted, that both of these things are in play. Linking up with a clearance attorney, I think, would be a really wise decision for a criminal attorney to do. And that, again, it will all be about helping to establish and develop the strategy that the client can buy into, and that way no pointing of fingers occurs later in time when they thought that maybe they were going to get this great outcome, and then all of a sudden they lost their job because of it, when they might have chosen a different route, might have litigated the matter rather than taking that easy out with a PBJ or something to that effect. So not only are we involved in linking up with attorneys on that, but we also help advise the clients when they're filling out their SF-86 and other things too, so that way they know when they already believe there may be an issue, they can wordsmith it and try to resolve the issue on the front end without having to go through this whole process. So that's the presentation. I hope you found it to be informative, and if there are any questions, we will be providing some slides for you to see that I worked through as I was doing this presentation, so that way you can refer to them, and also our contact information is found on that last slide, so that you can feel free to reach out at any time. We're happy to help however we can. Thank you.